Good afternoon, everyone, and welcome to Litigating from Home and Adapting to Zoom. Thank you for joining us. My name is Rebecca Newman. I'm an associate at Summerman, McCafferty, Casada, and Geisler, and I have the honor of moderating this distinguished group of panelists today on behalf of the DAYL CLE Committee. The CLE course number is 174092547, and Sherry has told me that she will be adding that into the Q&A so that if people join later, that's where that will be. Over the past few months, litigators and judges have all had to adapt to remote lawyering. Our objective with our time today is to discuss the challenges and unexpected benefits of litigating through these remote methods and how the pandemic might change the practice of law for years to come. We have a lot to talk about, so let me go ahead and introduce our panelists. Judge Monica Purdy currently serves as an associate judge supporting 7 of the 13 state civil district courts here in Dallas. Since Judge Purdy's unanimous appointment in 2013 by the elected presiding civil judges, she has consistently earned among the highest ratings of all her judicial colleagues and is ranked one of the top 3 civil judges in Dallas County. Prior to taking the bench, Judge Purdy worked at a national law firm practicing civil litigation before opening up her own private law practice. She's currently the Democratic nominee running for the 95th Civil District Court in Dallas County, and we're honored to have her join us for this panel. Andrew B. Summerman is a partner at Summerman, McCafferty, Casada, and Geisler. Andy is a board-certified personal injury trial attorney specializing in catastrophic injuries, wrongful death, and defective product cases. He's currently serving as the secretary/treasurer of the Texas Trial Lawyers Association, and he has received a peer review rating of AV Preeminent Award, the highest distinction awarded by Martindale Hupper. He's also my boss, so Andy, thank you again for agreeing to take part in this CLE. Dave Wishnu is a partner at his firm Crawford, Wishnu & Lang. Dave is a trial attorney focusing primarily on business, employment, and intellectual property disputes. Super Lawyers has named Dave a Rising Star each year since 2012, and this year he was named a Texas Super Lawyer. D Magazine recognized Dave in its Best Lawyers in Dallas and Best Lawyers Under 40 since 2018. Dave, thank you so much for joining us. Our last panelist is Joey Mongaris. Joey is a criminal defense attorney whose practice is focused on challenging criminal cases in both federal and state court. He's tried over 500 cases over the course of his career. One of these recent cases includes a case that reached the United States Supreme Court. Joey is an associate member of the William Mack Taylor Inn of Court and was the chairman of the Dallas Bar Association's criminal law section. Joey has the distinction of trying a rare pandemic era case in federal court. Thank you for joining us, Joey, and I can't wait to hear about that trial. Throughout the panel, if the audience has any questions to ask, please feel free to use the question and answer section. We'll also have time for a few questions at the end of the panel, but we'll do our best to incorporate your questions as we go. Now let's kick off our discussion by addressing remote depositions. Andy, what are some drawbacks of remote depositions that you've discovered, and how can those drawbacks be mitigated?
The main one, of course, is not being able to see people face to face, not having that personal contact that we have. The best way to mitigate that is, of course, the best technology that you can bring to that particular setup. I found that a lot of folks are having a difficult time throughout this process with remote depositions. And most of my opponents are willing to do live depositions, provided that certain criteria are met. For example, that there's a distancing of 6 feet, that masks are worn. We, for example, have provided additional protection. We have created a situation where we have, best way to describe it is spit guards. They look a lot like your high school presentation. It's a 3-sided matter. Here, let me show you what I'm talking about. The 3-sided piece of plastic. We put it in front of the witness. We put it in front of the lawyers. The witness does not have to wear a mask because they're behind a spit guard. Lawyers do have to wear masks. They're behind the spit guards as well, and you can videotape right through it, and so you can do live depositions. So that's one way to mitigate it. Now, of course, some folks just won't refuse, and you have to take the deposition. And if you do, the way you mitigate against those problems, of course, the biggest one is presenting exhibits to the witness. Of course, you can do that through the Zoom application or whatever application that you're using, but for we boomers, it might find a little more challenging than perhaps the younger generation along those lines, because we were not born with a computer at our fingertips. And so as a result, What I do is get the younger generation to assist me for the most part and have them deal with the various exhibits and the like, and that helps mitigate the various issues that we have.
Thank you, Andy. And then on the flip side, Dave, what have you found to be some of the unexpected benefits of virtual depositions?
Anywhere, anytime, any place. That's the absolute benefit of it. Scheduling has not become a problem anymore. Of course, during the time of COVID, there's a lot of folks with time in their hands. But you can also find them wherever they may be. I love the fact that I don't have to travel to San Francisco to take an expert's deposition. That expert's deposition can be taken just through the video. In fact, if we're talking about experts and fact witnesses, I prefer Zoom, quite frankly. I can get it done. I can get it done quickly, and the technology allows for ease of access. But if it's my opponent, I want them face to face. I want to be able to present to them the documents. I want to be able to feel it, as it were.
Thanks, Andy. And Dave Wishnu, I'm sorry. What has been your experience with virtual depositions?
I'd echo Andy's sentiments. I mean, on the benefit side, like you said, cost, scheduling, efficiencies, right? You can get more done and less time. You knock out the travel. The problem, we go back to, I know Andy and Judge Purdy. I mean, I remember taking depositions via phone. I did depositions via a similar Skype type technology before the pandemic. So it wasn't that big of a challenge. But the big challenge is not being able to be there to see your witnesses, to kind of get a sense and to, read their body language as well, the inflection in their voice as well. I'd say right now the benefits is that we can get more done. But unlike Andy, I don't want to take an expert or my key party witness via Zoom. I still want to do it old school, and I still want to be in front of them.
Thank you, Dave. Do you or any of the other panelists have anything else you'd like to add? Advice you'd wish you'd known before your first deposition, things of that nature?
Yeah, let me address what I call the cheats. The cheats are a bad thing. I've been in depositions now where my witness obviously has somebody else in the room, and you can see them acknowledging and watching them. I mean, it's like this. Okay, yes, that's right. That's the way I want to answer that question. You see them looking off at someone else while that's occurring. Now, if you want to talk about one of the most immoral acts that you could think of as a lawyer is to allow somebody else in there helping answer the question. One of the ways we help mitigate that is say, would you please pan the room right now? And they refused. So that told you a lot about that particular cheat, because notes can be passed, someone else can be in the room. You can pass notes through telephones, through the chat room, through cell phones, through email, anything. And this is a huge danger, in my opinion, about the time of COVID and doing the video depositions.
Thank you, Andy. And Dave, just to follow up on your answer about fact witnesses and expert witnesses, what do you think are the drawbacks to not taking those in person? And so why are you resisting those?
Maybe it's just a hesitance because of a way that I've gotten to know how to do things, how I built my practice, how my mentors taught me, and maybe I'm just being slow to adapt. But I like to be in the room with someone. I like to see how they look at exhibits, how they answer questions, and yes, you can see a lot of this virtually, but there's nothing that can take the place of being right there with them. And I guess that's my hesitance. Another thing would be I know that there's great technology with exhibits, but in a lot of times practically, you're kind of turning your exhibits over ahead of time. I know there's programs that enable you to, avoid that, but I know with my partners and our firm, we've seen where sometimes that's just kind of the nature of it, is that they're going to get to see those exhibits and what's coming for them before the deposition.
Great.
Rebecca, if I could just add to that from just the court's perspective, I just wanted to remind those that are here today to just make sure that you check the Dallas County standing order in our state district courts. There is a section outlined about particular depositions and bases that will quash deposition notices. Again, I think as you mentioned in my introduction that I am the associate judge for 7 of our 13 courts down there, and I have not seen a whole bunch of motions to quash, so our lawyers have been very good to work with each other to make sure that if they need a deposition during this time, that they do it remotely and that all the safeguards are put in place. But there are some particular sections that deal with depositions and motions to quash during this particular time frame in our emergency order, and you can find that on the website for Dallas County. So I just wanted to remind those in attendance today to check there as well.
I have a quick question for Judge Purdy. Judge, you know, traditionally when we've had disputes, we try to avoid them during a deposition, but when we've had to get you on the phone, have you had it where you've actually come in through the Zoom, through the Zoom where they're in the deposition?
I haven't had to do that. I have not had to come in and intercept a Zoom hearing. What I can tell you is that before the pandemic, I got a lot of those particular telephone calls, possibly when I was there working late at the courthouse, where I had lawyers in a deposition, maybe in Los Angeles. They were on the West Coast, and they had a dispute right then. They need a ruling from the court. So we always like to tell practitioners that that is a service that is out there. I'm certain if you called the courthouse, whatever particular court your case is in, and told them that we need a ruling, we're in a deposition, we want to forward the judge the Zoom link, that we will be amenable to get that done for you. But that's typically how we've taken care of it pre-pandemic, but I've not had to get into any particular Zoom hearings to rule on a particular matter.
Great, thank you, Judge Purdy. And I just want to follow up and ask you, what types of pandemic-related litigation are you seeing or do you expect to see in your court?
Well, obviously, I think one of the biggest things that we're seeing, we know that for a while there was a moratorium on evictions that has since been lifted. Typically, the normal flow with evictions is they start in our Justice of the Peace Court, they're appealed to the county court, and I would say sort of as a last court of equity, sometimes we have tenants to come to the district court for some type of equitable relief. So we are seeing more with evictions, sort of title disputes that are intertwined with those particular cases. We've seen constitutional litigation as it relates to shutdown orders and constitutional orders that have been put in place. One of the ones that probably garnered a lot of media attention that everyone is aware of are the beauty shops and the barber shops that have been shut down. There's also been litigation that has been drafted on behalf of standalone bars being treated differently from maybe a bar in a restaurant. They're challenging some of the constitutionality of these orders. Obviously, breach of contract issues are coming up during this particular time. I can tell you that I've seen quite a lot of TROs as it relates maybe to a promissory note, maybe someone that is doing business with another entity. They simply have shut their doors during this particular time. They've gone radio silent. They had a payment that was due and they're nowhere to be found. So those kind of things that we're seeing. In terms of litigation that I think we might see as a result of the pandemic, obviously business interruption losses, those types of things, claims against business that deal with vulnerable populations such as nursing homes, whether or not, I think we might be seeing whether or not employers are adequately protecting their employees with personal protection equipment in order to do their jobs. Let's see, what else did I write? Claims against insurance, whether or not you are totally insured for this type of pandemic, for this particular type of loss. There's been a lot written about force majeure clauses and whether or not this covers COVID-related type of litigation. So we've seen it from all over, but I can tell you during this particular time, it's mostly the evictions, it's mostly TROs to have a payment sort of sped up, that type of thing, and the constitutionality of a lot of the orders that we're seeing put in place by our county judge, as well as our governor here in our state.
Thank you, Judge Purdy. Now moving on to a discussion of remote hearings. Andy, have you found that remote hearings have affected your practice positively or negatively? And do you think they should continue after the pandemic is over?
God, I hope not. I really hate remote hearings. There's nothing better than to get a feel for a judge while you're giving your argument. There's very little that I can think of that is a benefit to doing remote hearings, except for, again, the convenience, the ease with which it's accessed. Getting documents to the courts are very challenging, and almost every court has a different way of doing it. For example, in Tarrant County, you have to think way of email. Some of the judges in Dallas County want notebooks. Some of them just wanted to present it on the platform that they're using. And judges are using different platforms, some Microsoft, some Zoom. Now I have to get to know a different type of program. I hate this. I can't think of too many benefits of it except for perhaps one, and that is the very thing that I was talking about being immoral in terms of depositions you can do in a hearing. And what I'm talking about is you can have your genius associate in front of you giving you hints. No, that's the bad case. No, this is a good one. And you could probably get away with it so long as, it's very subtle and, Judge Moyer doesn't notice it.
Thank you, Andy. Judge Purdy, have you seen many common mistakes that attorneys are making in relation to their remote hearings, such as their appearance, the background, failing to request a record, things of that nature?
Well, I can tell you for the most part that people have been dressed properly for these hearings. Whether or not it be a suit on, and it has been presentable. Most people come on, most men have on a jacket and a tie. Every now and then, and I'm probably a little bit more relaxed than some, I field a lot of the TROs that are filed in Dallas County. And so I might get a lawyer that's, pretty much out jogging that say, Judge, I apologize for my dress. I literally just got this 10 minutes ago. I did not have time to go home. And certainly in those types of circumstances, I'm going to allow them to proceed because I want to have both parties in front of me when hearing a TRO and trying to decide. So for the most part, I think that everybody has been very cooperative. I've not seen anybody roll out of bed and try to come into a hearing. Like some of the headlines, I know judges around the state have been talking about different lawyers' appearances before Zoom hearings. So that has not been that's not been my experience. The only thing that has been weird about some of the remote hearings, of course, is technology. And when the technology fails, how do we get everybody else on? I think, maybe during those first few weeks when we were in the shutdown, when everyone in your house is on internet, including your kids, and maybe kept buffering and those things, that's mainly, but I think we've worked all those kinks out. For me, if I have pro se's that are in my court, then I'm going to transfer to sort of a telephone type of hearing. Because again, it's my desire to have everybody before the court. So it's worked pretty well for me. I miss being in the courtroom. I miss seeing people that come before you. I think there's a lot of benefit as to what Mr. Summerman said, that you can gauge the judge, you can gauge those parties before you. In terms of one of the questions that you asked him, are there any things that you would like to see remain? My thought on that is pretty much anything that is going to allow the court to be efficient. I would be open to doing that in a courtroom. For instance, something like a dismissal docket on a Friday afternoon, I think that can be accomplished by a telephone docket. Just some very administrative things that is not going to require that lawyer to come down, charge their client. Those would be things that I would like to see remain after this particular pandemic, and would be interested in exploring more. Just some of the more routine type of things that require a lawyer's appearance that I think can be done over the telephone. So those are my comments.
Thank you, Judge Purdy. And Joey and Dave, do y'all have any thoughts on remote hearings? I know, Joey, you said you've done some federal sentencing hearings.
Yeah, so the federal sentencing hearings went, I've had two, and they went well. I always prefer in sentencing to be present, again, because if you're going to have witnesses on behalf of your client, and you're trying to get a departure, I always feel that it's better to have those people present in court where the judge can view them and talk with them. But I had witnesses in one, and it worked out really well. If your client is in jail, for instance, where one of mine was, that there's echoing, they don't get a feel in speaking with the judge as well. And sometimes it might come across disingenuous when it's just nerves or something along those lines. As far as just your regular, like Judge Purdy said, your administrative things, as far as arraignments, that would be great to continue remotely, where your client is just saying, yes, I plead not guilty, where your client, or even a plea agreement, where you go in and have a plea. If your client is in jail, that would save a lot of time. And sometimes you're just sitting in court waiting on the next one and the next one. So I think that would save a lot of time. And so I'm pro that. The sentencings, I understand why we do it. And again, I don't mind that. It just, there are some that you're going to put on a really good, if you have some battling and some issues, I think the in-person is still preferred.
Joey, for those of us that don't practice criminal law, I mean, are you doing your hearings via Zoom? And is there a camera ready for your client when it's his turn? Is it a courtroom technology? How's it working?
Yeah, so actually both on the state and federal level, they've been doing very well. On the federal level, if your client is not in jail, they'll get the same. It's not through Zoom. I think it's WebEx. It's more secure. And so if they're at home, they can talk. They say, I plead not guilty. Or, if it's a plea agreement, then they're pleading guilty, and everyone's kind of on a Zoom or WebEx and federal. In state court, at least in Dallas County, Tarrant County is open, so you're going there. But in Dallas County, you can do virtual pleas as well. A lot of judges prefer Zoom. And just like Andy was saying, other judges prefer, I think, Microsoft Teams.
Right.
And so it's figuring that out. But as far as it's really easy once you adapt and learn those to do, especially in Dallas County, you can do a virtual plea, and everything is signed beforehand. There's no paper. Everything's electronic. And so the clerks don't touch anything. The judges don't touch anything. They're all signing everything virtually or on Adobe. And so it works out. Once the kinks have worked themselves out, it's actually gone pretty smoothly.
Great, and we actually have a question from the audience from BB Sanford, and I think this is directed to you, Judge Purdy. Do you think courts will allow a hybrid hearing approach where one attorney is allowed remote while the other prefers to come in person?
Well, I'm only speaking for myself today, so not the other judges, and I think it's just going to be a matter of personal preference for those particular judges. Even before the pandemic, you have lawyers that will call and say, I can't get to the courthouse. I have to be this particular place. May I appear by telephone? And certainly, my rule has been for the particular courts that I sit for, if I have a lawyer that obviously has to be down in Harris County in my court at the same time, and obviously they cannot do that, I'm going to allow them to participate by telephone. So I think, it depends on the particular court in which you would fall. I probably wouldn't want to have a blanket ruling where I would, or a blanket order or a blanket procedure that says that that's allowed. But usually if there's some unique circumstance going on, I think that most courts are going to want to accommodate you. But it has to be unique circumstances. And I can also tell you that when people have told me they have to be in another court or they have this at a particular time, I have called to confirm that is indeed the case and that someone is not trying to pull the wool over my eyes. So just know that wherever you say you will be, it will be confirmed. And most judges do that from a just a practical point. And if I call over to Tarrant County and they say we don't have anything set for him, then my answer is probably going to be no for the remainder of that particular request, that you're not going to be able to do that. So I think that it just depends on the court in which you fall and the circumstance.
That makes sense. We have another question from the audience from Alex Reisinger. And I think this, Joe touched on this a little bit, but how have clients and witnesses responded to having to use video conference? We've had to adapt to it as lawyers, but how have lay people adapted in your experience?
I'll jump. Oh, Joey, go ahead. You take
Yeah,
it.
no. Most have adapted pretty well. Sometimes you have clients, honestly, that don't have the video equipment. And so we've had to have those people come to my office and set up a computer for them. And if they don't have a video, they're sometimes just uncomfortable in general with the electronics. So for the most part, I haven't had any client complain, to be honest with you, about it. And most of them, other than sentencing, have, again, been things that are relatively short and fast and can be done over Zoom.
Yeah, I've seen other people's clients, the defendants, for example, not doing too well with it. They choose terrible backgrounds, a drunk driving case, and there's a sign behind them in their house that's talking about, how much they'd rather be drinking than doing anything else. This is not good. Usually you can control that, but sometimes folks are having a little challenges there.
One thing that I want to add. I'm sorry, Dave. Go right ahead.
Oh, I'm sorry, Judge. All I was going to say is, I've found that, sometimes we've said that the law has lagged behind, technology and what other businesses are doing. And I found with a lot of businesses that they're more sophisticated technology than we are. And then they're used to being on Skype and Zoom and stuff all the time. So for them, this is just sort of, the ordinary course.
And what I was going to add to that particular response, I agree exactly with what Dave has said. Again, just going back to the context of TROs, I've had business owners that, they've got Zoom on their iPhone. They're technologically advanced. They know what they're doing. They're able to participate in the hearing. Where I've also had a pro se person that, just has a telephone number. They don't even have a cell phone. So I think, there has to be a balance between our technology and where the law is, because I think one of the greatest things that this pandemic has revealed to us is the big digital divide that we still have here. Basic internet service, it's not as basic for everyone as cable, air conditioning, water, and gas in your home. There are still a lot of people that do not have that. And we have to remember that there's still a lot of pro se people that come to our courts. So we have to be very accommodating to them. And I think like I said, I think our public school here in Dallas Independent School District revealed to us just how sharp that digital divide is, how many of our children still don't have internet, and how many of the teachers don't have internet to even teach remotely. So I would just ask that you take that into consideration and also be accommodating of those people that are just not quite up to speed with the technology. But I've seen everywhere. I've seen people that are more savvy than me on the technology, as well as a pro se person that can simply just call in on their telephone.
Thank you, Judge Purdy. We have another question from Haley Jones. What advice do the panelists have for dealing with lawyers who are using the pandemic as a means of delaying the process of a case and refusing to take depositions or discovery remotely?
I'll lead that off. It's happening. In fact, it's its own epidemic in and of itself. The excuse COVID. In fact, it's almost become a call sign. Anytime anybody wants to delay anything, COVID is the answer. It does get traction, and it's getting traction with the courts. Anytime you want to delay something, you can invoke the pandemic to get it done. The only way you can do it is to press the court, ask them for help, say, look, offer a solution, why it is that COVID should not impact the way that you're doing this deposition, this hearing, this document production, this answer of interrogatory.
Thank you, Andy. Now I want to talk a little bit about mediations over Zoom. Dave, have you found virtual mediations to be effective in comparison with in-person mediations?
Well, when you asked me when we first joined this panel, I would have said, I was going to say, yes, I was surprisingly impressed about how mediations have been as effective because, you know, the thought being is that if you force people to get into a room, you force their attention and you know, you make them confront, you know, the issues, especially in the types of cases that we handle. And they've really got to sit for hours and evaluate risk and reward and cost benefit. It gets deals done. And my thought was going to be that how is it that if someone's going to be halfway on their computer, you know, doing something else versus halfway inside the mediation, how is this going to be as effective? And you know, up until a few weeks ago, I was thinking, wow, these are surprisingly good. I mean, you know, the mediators kind of pop in and pop out, and it takes a little getting used to, but you know, we're still getting, you know, cases resolved. But recently, kind of what my earlier concerns have kind of held true, where I don't think you've got the full attention of the decision makers. They're still handling, you know, lots of other things during the mediation. And it's not as if when we're in person, you know, people aren't working on other things when there's downtime. That, of course, happens. And all of our lawyer jokes get old at some point during the day. I mean, my preference, I think, like Andy's, is I want to return to, you know, forcing people to do it. Now, the benefit is scheduling, especially when there's multiple parties. When you're trying to herd cats and get, you know, all these parties, lawyers, and you're maybe dealing with insurance companies, it's hard to get people to all in one place. So the benefit is the scheduling, the efficiencies, and you know, being able to get them in.
Yeah, that makes sense. We also have a question from Andy Jones, just following up on your answer, Dave. Is it the format of Zoom, or is it the lack of trials, do you think, that's keeping cases from being resolved at mediation?
I think it's both. I think it's one that, like what Andy said, which is defendants can now use delay, you know, better use delay as a tactic. It's always been there. And look, we do both sides at our firm. And so look, sometimes there's a case where you're fine with it, you know, dragging out. And it's frustrating on the plaintiff side when you're trying to push it and you're getting the things that Andy said, the delay. So I think that's part of it, is that they don't see a trial date on the horizon, or even if there is one set, nobody really truly expects it to go. So that's part of it. And then the other part is, I think that you're not forcing someone into a room. You're not forcing them to sit there all day, to listen to the mediator, to maybe do an opening session. And so I think both of those kind of factor in.
Thanks, Dave. And Andy, are you experiencing the same ups and downs of remote mediations as Dave is?
Yes, I do find that certain mediators are more adept at it than others. In fact, some are really, really getting good at the COVID mediation, as I like to call it. But to answer the previous question, do I think that the lack of trials is a problem? The answer is hell yes, it's a problem. You know, there's nothing like having 30 days out to be able to force somebody's hands to finally make a decision that says, all right, you know, your choice is to pay me or try me. And right now, the try me ain't happening.
And Andy, do you think that remote mediation should continue, or do you think that we should go back to live mediations when this is all said and done?
Yeah, I like live. You know, I really do. There's nothing better than to be present, as was said. Dave's right. I mean, there ain't no doubt about it. You know, there's nothing better than being in the room and forcing their hands. You know, I never let the adjuster show up by phone. Never let that happen. You know, I just be there just like me. Focus is the answer. And I think Dave hit it right on the head right there.
Hey, Joey, real quick, I got a question, because we're doing mediations in the civil sense. How is it, you know, with respect to plea deals that you would otherwise expect to happen or not? I mean, how is that affecting, you know, getting your cases, your clients, the type of deal that you think is fair and what they should do if in fact it's right for that particular case?
Yeah, so that's tough. Along with probably a lot of defense attorneys, part of it is your relationship with the prosecutor. You know, because a lot of times a judge accepts it, but again, the prosecutor has all the power to initiate a plea. So on the state side, you're trying to negotiate a plea through either telephone or email. People kind of puff out their chest a little bit on email more so than they do if you were there in person talking with them. And at the same time, you can't relate the mitigating factors that you want to relate about your client. And say, look, you know, he has this going on this, or she has this going on in this, and this is why we want this deal. So as far as plea negotiations, it's a little tough. On the federal side, it's a bit different because they've worked their case typically for a year or 2 years prior to, and you're at that point just trying to catch up and get the discovery before you can even speak with them. And so it is difficult, and I echo everyone here in saying, especially Andy and Dave, in saying that you can't really negotiate, in my mind, and I've talked to other defense attorneys about this, as well as on a phone call. Sometimes on a phone call, maybe a little bit better, but especially not through email. And so virtually, it's still not the same as speaking with the prosecutor in person and being able to present your case to them of why you want a certain deal.
Thank you, Joe.
Yeah.
We have a question going back to something we talked about a little bit earlier with regards to witnesses and depositions. Callie asks, when a witness for deposition is present in the law firm of their attorney, is it your preference to have the attorney on another computer or in the room with the individual being deposed? I think this is something you talked about, Andy.
Yeah, they've got to be on their own computer. We got to be able to see what they're doing, because you don't know what sort of signs or signals are happening otherwise. I think it's a dangerous practice. In fact, I oppose it. I just won't let them be in the same room if I'm not in the room with them.
Dave, do you have a similar policy, or do you think that's appropriate?
I agree 100% with Andy. I mean, unfortunately, you know, there are lawyers out there that, you know, will, you know, cut corners or bend the rules or break them. And I don't want that to be an option for them. I mean, there's a story of a very, very well-known lawyer in town that was during a very well-known businessman in town's deposition that was like crawling around on the floor during the deposition as more of a distraction and whatnot. And those are just types of things that you've got to be able to control. Like Andy said, are you scanning the room? You're making their face be on the screen. You've just got to eliminate the risk. And it's unfortunate because I think most lawyers won't do that type of thing, but there are some, and you got to be able to protect your client.
Thank you, Dave. I want to turn over to a part of this this presentation I think is on everyone's mind, especially us as litigators, which is trial and how is this going to happen during the pandemic. Now, Joe, you've had the unique experience of actually trying a case during the pandemic, so can you share any insights with us?
I have a lot. I'll try to condense them down. I will say this, as far as how preparing for that is difficult because you don't know kind of what to expect. Mine was a federal trial, and so we did have, myself and the prosecutors had a pre-trial where we had communication with the judge and kind of asking what was going to happen. I filed a pre-trial motion asking for safety precautions, in essence a motion in limine. I kind of made it up as a hybrid saying, you know, we want extra safety precautions. And luckily we had Judge Lynn had just tried a case in the Northern District 2 weeks prior to ours. Granted, that was a one-day trial, but the Federal Public Defender's Office was very helpful in speaking with them about how to proceed as well. So as far as, and I don't know if you want me to go into kind of jury perspectives and things like that.
Please.
So, and this is, we had the judge, I believe, had sent out about 100 summons. Only 15 responded back saying they did not want to appear due to COVID. During voir dire, I'm the only one that addressed COVID-19 during voir dire and the fears and dangers of that. And so I believe probably another 10 to 15 jurors expressed fears. Probably 10 of them did not want to be on the jury. They didn't want to wear masks all day. They were fearful that they were going to be in a courtroom with other jurors and not being distanced quite well. That's another thing. I had asked for voir dire to be in, Judge Lynn did this. I'd asked for voir dire to be in 3 separate panels, so there wouldn't be, so jurors would be separated out 6 feet. This was a rather large courtroom, and even with the size, I think 3 feet was about as far as they were, and one juror basically said, I feel like I'm in an airplane right now. I just don't feel comfortable being that we're supposed to be 6 feet apart, and even though we're wearing masks, we're in this room at least for most of the day, and I just don't feel comfortable. Another juror said, I didn't, this is the first time I've used a public restroom. Our trial was in the end of June. It's the first time she used a public restroom since February, and then no jurors wanted to drink from the water fountain. And so they had all expressed that. And so that was, as far as, that was the only jury perspective I got was during voir dire. That's the only time I could speak with them. With witnesses, I echo what Dave and kind of Andy are saying. We had asked that kind of a glass partition be placed so the witnesses would not wear a mask. Because it's hard to judge. This was a multi-defendant case where a lot of people were coming to testify against my client. And so it's very important that the jury judge that witness's credibility and the agent's credibility when they got on the stand as well. And so the judge allowed that witnesses not have to wear a mask. And so while we didn't have a glass partition, they were actually in the jury box while the jurors were in in the gallery. That also posed a problem because if you're, we had 12 jurors and I think we had 5 alternates just in case somebody got sick. And so, the alternates and I assume jurors 8 through 12 couldn't really see the witness because of how big the courtroom was. So then how do they judge the credibility? Another issue was my client and I and co-counsel, we had to sit 6 feet apart from each other. So I had to ask the jurors, are they going to hold that against me, that I'm not right next to my client asking him what to do? And so that also posed another problem with notes and client communication, attorney communication. So I took this from the Federal Public Defender's Office, this idea. I brought my client a computer. And so we did Microsoft Teams if he had, instead of passing me a note or talking to me, he would type on a computer. So I had to address that in voir dire. If you see my client talking, typing on a computer while testimony is going on, are you going to hold that against him? And so I had to ask that also that the U.S. Attorney's Office sit 6 feet apart from their table. That way it doesn't look like I'm scared of my client in this. So I address this in a motion in limine, and we try to talk about this, but you don't know what a juror's, and they all said, oh, that's fine. But there's no way that, the U.S. Attorney's Office has 3 attorneys, 2 agents, and their paralegal at the table. They weren't 6 feet apart. And so while myself, co-counsel, and my client were 6 feet apart, I think that poses a problem, and especially in a criminal case where you have the presumption of innocence. So I could go on and on. I'm sure if you have other questions, but those are all the really just kind of how the jury is going to look upon your client if you're distancing from your client, how that's going to affect a jury's perspective on whether you might be scared of your client or not want to talk to your client, and the reality of that, and kind of whether the jury can listen and see witnesses, especially in a case where there's many co-defendants coming in to testify and agents testifying with regards to that's an issue. Also during voir dire, I wore a mask. I decided when asking witnesses questions not to wear a mask because we were 6 feet apart at that point. But that was very difficult as well. Relaying. I like to think that, like Dave said, I like to think sometimes I'm funny and sometimes I have good jokes, and that sometimes you have some charm, and that does not come across when you have a mask covering your face and you can't smile at a juror. You can't give them the nod that you would typically give them when you're asking one juror a question and another juror cuts in. That is very difficult to do. And so those are all, I think the court addressed most of those concerns very well. I think it's going to be difficult to if you don't have a large enough courtroom and you don't have the resources to conduct that, the jury deliberated in the courtroom while we left, and then during the trial, they were not in the regular jury room that the courtroom provided. They were in another courtroom that they could sit 6 feet apart. So there's a lot of concerns. The courts are trying to address those, but I think Judge Lynn, there's an article I think on law.com that she wrote, and that was very telling on moving forward if we're going to have trials, what it's going to take.
Thank you, Joe.
Yeah.
And on that same note, Dave, we had talked about while we were preparing for this discussion, a recent survey that was conducted by the Tillotson law firm that was suggesting jury pools would be drastically different in composition for jury trials if they were called today. Can you speak a little bit on that?
Sure. Jeff and I actually, we were going to try to be the first Zoom trial. We were going to see some of our friends in the personal injury business, maybe establish a high-low. One of us take plaintiff, one of us take defense, and then as we were setting it up, our friend Amy Stewart beat us to it and got the first Zoom trial in. But so good for Amy. But no, Jeff has interns every year, and he always puts them to do interesting tasks and interesting studies. And what he did now was last summer, or during the pandemic, is he's done a poll in Houston and Dallas, and the results are pretty shocking. In as far as people that feel unsafe with trials, 52% in Houston, 40% in Dallas, that there are no measures that could make them feel safe. 21% in Houston, 19% in Dallas, 56% across the board said that all jury trials should just be delayed indefinitely. 44% in Houston, 36% in Dallas said they'd be angry if they were called to trial. 57%, around 57, 58% all agree that social distancing and face masks should be required. And then you look into particular demographics, like economic hardships. A larger percentage of African American were polled to qualify for economic hardships than white, 45% to 31. As far as who would respond to a jury summons, 50% more men polled would respond than women, and 50% more Republicans than Democrats. And then, so what the results are, and what Jeff would tell you, as he told me, is the results are right now, if you were to have a jury trial, and you're going to get what would be traditionally thought of as a defense jury. And his further research that's not in the article would talk about that. We've always had the belief that if you're a plaintiff, you'll take a 6-person jury over a 12-person jury because it's easier to convince 6 than 12 is a traditional school of thought. And what he's found is that's actually mathematically incorrect. It's largely dictated by the judge. But if you're on the defense side of the case right now, and you can get and you've got the opportunity to present perhaps a trial in a favorable court of 6 people or even 12, and you can do it. Doing it now the statistics would say would be better for you than waiting for when sort of the pandemic ends and the traditional jurors are being called and are showing up and are being part of juries.
Yeah, if I can echo just a little bit of that as well. We filed a motion for production of jury records as well to get, and I filed kind of a hybrid motion as well. And we actually had a hearing with regards to not getting a proper cross-section of jurors. Now, the Eastern District does kind of what the Northern District does. They pull from people from voting records and driver's license records. And I probably did too much research on this and still don't know enough. Joel Page from the Federal Public Defender's Office is kind of who I spoke with regards to filing this motion and trying to get, but I would recommend if you're going to have a jury trial that, and I don't know in the civil aspect of this, but I would definitely ask for production of jury records for at least the past 5 jury trials prior to the pandemic, and then the summons you get, and compare that. Now, because of the way the jury pool works, you know, some of those summons might not have gotten to the people because they might have moved in different cross sections. And we, Dallas Morning News had a good article, and the article Dave was referencing to as well was very helpful in trying to show the judge that, you know, the African American community and the Hispanic community, whether it's Dallas County or even in the Eastern District up in Sherman, have been affected. And so if they've had to move because they've had to find work somewhere else and they've lost their job, they might not have gotten summons that they would have gotten 3 or 4 months ago when they did have a job and when they weren't affected. And so I think that's very important if you're going to try a case to at least look into filing that production of jury records.
One of the things that I was going to add with respect to that too is just based upon the fact that you want to have a jury pool that is representative of the community in which you live. And with this pandemic, listening to science and listening to science alone, we know that minorities have been harder hit by COVID-19 than some of our other communities. And if you have a jury that is not representative of your peers or a good cross-section of the community, then you need to take that into consideration if you're going to have a jury trial. So I think those are some of the concerns as we move forward. Are you actually going to have a pool that's representative of the county in which we live? I don't know. I don't know the answer to that. I mean, I was surprised, Joey, when we talked about the fact that there were only, you know, so many people in the trial that you participated in that said they didn't want to come because of COVID. I think I had mentioned to you before we actually got on broadcast here that there's a no-show rate of 20% in our state courts. That's never really a welcome summons to receive in the mail. An important one, but it usually doesn't come at a welcoming time. And how many more people are not going to be, I think we heard those statistics from Dave, they're going to be angry if they get a jury summons right now.
No, especially when they come to court and see if they're not distancing or somebody forgot a mask and they have to get a mask. And, you know, especially in that board, it's almost impossible unless you have unless you do a voir dire and 3 separate voir dires or 2
Right.
to distance properly. And so a lot of, you know, you had jurors, and we had a pilot that said, you know, this is how it is in our airplane. Judge, you have to require everyone to wear masks.
Right.
And so they'll get even more upset. And I think that's what we had. A lot of jurors thought, okay, well, I'll go and see how it is. And when they got there, and I will say the court did everything they tried to do within the means that were possible.
Thank you, Joey, and thank you, Judge Purdy. And just sort of jumping off from that topic onto remote trials and the possibility of having an entire trial in a remote method. Do you think that that's practical, possible? What do you see as being the benefits and the drawbacks of that potentiality?
Well, I'll go ahead and start first. And again, I'm just speaking for myself and our state courts, but I think we're up against what most entities find themselves up against at this particular time. For instance, our school systems, they're trying to figure out how do we socially distance. We only have one particular building. It only has so much capacity. I think I heard a superintendent maybe from another state or something mention he would need almost 5 or 6 other schools the size of football fields to actually distance all of the population that they would have coming to that particular school. So I think logistics is an issue. I think something, again, that I mentioned earlier on, if we sort of had a sense as to when this pandemic might end, that would be helpful, but no one has that particular crystal ball. So, you know, if we're going to be in this particular state for another year or so, I know that there's going to be some trial lawyers that want to go to trial. We're going to have to figure it out. And we're just going to have to deviate from what we've known about trying cases and make it work. Because I don't know that we should go that long without jury trials. I think it's needed, it's guaranteed to us, and is something that we'll have to figure out going forward. Lawyers are innovators. You know, we solve problems, we get things done. So we'll have to figure out how in which to do it. But I think safety is paramount in that particular process. Safety for the judge, the court, the staff, the parties, and those jurors that are coming down. But I think that if we're in this for too long, it will have to be figured out by our state court systems as to how we move forward.
And Joey, do you think a remote trial would have mitigated any of the problems that you faced in your federal court trial?
I think they'd exasperate some of them. Not the credibility of witnesses, not being able. I couldn't imagine conducting a voir dire virtually. I guess it could be done, but in cross-examination of some witnesses that you really think have credibility issues, that would be very difficult to do remotely. I think maybe a trial by judge would probably be a little easier when you kind of know what you're going to get. That maybe, but on the criminal side, especially with that presumption of innocence and some things that you have, I think a lot of defense attorneys would probably be in the same boat, that would be very difficult to do in that sense.
And Andy, do you agree that trying to attempt voir dire on a remote trial would pose significant challenges?
Yeah, I'd rather shoot myself in the face than do it'd just be about the worst thing I could possibly imagine. But Dave kind of touched on something that both he and I apparently are doing independent of each other, come to find out, but that is summary jury trials that I think is coming. In fact, we've got one coming up in Collin County where we're going to try a case for 2 hours, each side having only 1 hour. And it's basically nothing more than a PowerPoint with some video clips in it. We are going to get a Collin County jury to review this and make a decision. And the decision is binding only because it's a high-low. We've agreed terms of the high-low, and that works out quite well. But that's about the only way I can see trying a case virtually. Dave, is that your experience as well?
That's my experience as well. I mean, look, I think I agree with everything Judge Purdy said, in that if this is going to last a year or 2 years, I mean, nobody really knows. We've got to start having trials. The problem is, you'll probably see is that most of them have to do by agreement, right? Because with all the problems, I mean, it's hard to force someone to trial in this uncertain environment. Pick a jury, like Joey said, voir dire. I can't even imagine how difficult. I mean, it's already hard enough, to talk to a panel of 44. I don't know. But like Judge Purdy said, we've got to keep the justice system moving. So maybe it is more agreements to do bench trials and waive jury trials. But some lawyers just don't want to agree on things. So I don't know. It's no good answers to these questions, unfortunately.
We need a vaccine. That's the answer.
I absolutely agree. We have one more question, and we have just enough time for it. It's from Raha Asadi. She asks, to any and all of the panelists, do you think post-COVID depositions and hearings will be more frequently virtual given the time and cost savings benefit? I.e., will there be more of an analysis on the value of seeing this witness in person?
Absolutely. I mean, I don't need to jump in. I think we'd all agree, which is it's changed the way we're doing things. It's making lawyers like me, maybe lawyers like Andy, that were hesitant to use any sort of the new technology at all, because I like to do things my way. I'm having to do it. So there'll have to be more of it. And it does enable you to have those efficiencies. But you're still going to have people, I think, Andy, not to keep using you as an example, but Andy and I prefer in person. I want in person. I want it back to where it was. But it's definitely going to change the way we practice.
I agree. I agree completely with that. To answer the question, yes, it will have some, it will have some of that, but not a lot of that.
Great. Well, we're ending just on time. I don't see any other pending questions. So I just want to take a second to thank you all. Thank you, Judge Purdy. Thank you, Andy, Dave, and Joey for joining us in such an interesting and timely discussion. I'd also like to thank the DAYL for facilitating and organizing this panel. And thank you to everyone who tuned in and asked questions. We got a lot of them, which I really appreciated. If you have any lingering questions for the panel, I'll post my email in the Q&A and make sure that your questions get to the panelists. So thank you everyone for participating, and have a great rest of your Wednesday.
Thank you.